For clarifications, Mr. Sito Ipin.
Thank you, sir. I thank the four ministers for their statements. I have 2 points to raise. SMTO was consulted by Minister Shanmugam to step in to make decisions should the then SMS Indrani need to escalate any matter. We know that SMTO was not called upon to make any decision at that time. But given the above, I'd like to ask whether it is appropriate for SMTO to oversee an independent review of the matter. Second point I'd like to raise is this. The CPIB report states that Minister Shanmugam asked the then DS Law for a list of properties available for the public to rent. CPIB subsequently found that there was no disclosure of privileged information and no preferential treatment given to the ministers and their spouses. I would also like to ask if it was appropriate for Minister Shanmugam to ask for this list. Thank you.
Thank you, Mr. Deputy Speaker. These both are very pertinent questions. First, with regard to myself, there is no conflict of interest for me to conduct the review. I'm not involved in the rental transactions of both these properties. I'm not a party to the transactions, nor a participant, nor have I taken any actions or decisions regarding the rental of these two properties. So I'm not an involved party. I'm not a subject of the CPIB investigation, nor indeed a subject of this review either. Sir, I think it's important to know that the Prime Minister has directed the Corrupt Practices Investigation Bureau to investigate and determine if there was any corruption or criminal wrongdoing in the two rental transactions of the Ridout Road state properties by the two ministers. And the investigations by the CPIB are independent, thorough, and authoritative. And in my review, I have relied extensively on the CPIB's independent, thorough, and authoritative reports. So, sir, I have no difficulty conducting this review as an independent review. On the subject of the Minister for Law having asked the Deputy Secretary for Law. So this point actually was noted by the CPIB in its investigation and was reported in the CPIB's findings. So in fact, this point was looked into by the CPIB. The Minister Shanmugam asked the DS in the Ministry of Law for a list of properties that were available to the public for rent. And this was stated in the CPIB's report. CPIB looked into the matter and found no evidence to suggest any abuse of position for personal gain. CPIB also concluded that there was no disclosure of privileged information in the process of the rental transaction. The AGC reviewed CPIB's investigation papers, concurred with CPIB's findings and recommendations, and directed that no further action be taken as the facts did not disclose any offence. Sir, which state properties are available for rent is public information. I've explained that. Minister Edwin Tong has explained that. They are available via SLA's managing agents responsible for marketing the properties on SLA's State Property Information online system, prominently displayed with 4 lease signs at the premises, and available if a credible potential tenant asks SLA or the MAs. So it is in SLA's and MA's interests for the properties available for lease to be made known to credible prospective tenants. SLA and MA want to rent out these properties, so they want people to know about them. Hence, if a credible prospective tenant were to ask SLA or the MAs which properties, for example, with certain characteristics that the credible potential tenant has in mind, are available for lease, the SLA or the MAs will provide the appropriate information, including on properties not listed on SPIO, but available for rent. This is not privileged information. The SLA or the MAs have received inquiries from ambassadors, company executives, or professionals to rent state properties. And SLA provides the information to companies too. Let me give members an example. In June 2019, SLA provided a list of several state properties to a company which was looking to rent several properties for its employees, for its operations in Singapore. It is, in fact, a 22-page slide deck listing more than 10 properties of various types. The listing includes the locations and characteristics of the properties so as to help the interested organization or person to decide which property to rent. And site visits could be arranged or would have been arranged. So, sir, this is not unusual, and it's not privileged information.
Mr. Pritam Singh.
So if I may add on to that answer, Mr.
Yes,
Deputy Speaker,
please.
sir, because the question is, why did I ask the Deputy Secretary? I think I should clarify precisely why. I could have approached SLA directly. They would have given the list. I know that they would give this information to credible potential tenants. Call them prospects. You are a landlord, you have properties, you want to rent. It's in your interest to give the information if you believe that the person is someone who is able to rent what you have. You will make available the information. So I could have asked SLA directly, and I know that SLA has given this information to others who will fall within the category of credible prospective tenants, embassies and so on, companies, business persons. And I think from SLA's perspective, I would be a credible prospective tenant who is not going to run off without paying the rental. But I asked the Deputy Secretary, senior admin service officer, so that Ministry of Law knew and there was total transparency. Instead of asking SLA directly, he will usually let the permanent secretary know. And as senior admin service officers, he and the permanent secretary will be able to go beyond me and report to the head of civil service or the Prime Minister if they felt that anything needed to be brought up to that level, either the Deputy Secretary or the Permanent Secretary. And that is how our system works. So I believed it was better to ask him rather than ask SLA directly. So the purpose of asking the Deputy Secretary is important. Some of the comments that have been made so far, I think, are made based on not realizing that SLA will give these lists and has given these lists to others. They are not privileged or secret information. If they are secret, SLA cannot rent out its properties. Once that is understood, then the question is, should I have asked SLA directly or through the Deputy Secretary? And I've explained the reasons why I went through the Deputy Secretary. Thank you, Mr. Deputy Speaker.
Mr. Pritam Singh.
Thank you, Mr. Deputy Speaker. Sir, the issues that have been covered by the four ministers, I think for many Singaporeans, cover multiple issues of concern ranging from propriety to policy to political optics. While CPIB did not disclose corruption or criminal wrongdoing, the two themes I will cover in my questions cover good governance and land management and reserves. My first question pursues the initial question raised by Mr. Sito Ipin, the second question raised by Mr. Sito Ipin, and that is with regard to good governance and Mr. Shanmugam's decision to ask his Deputy Secretary, a very senior civil servant, for a list of properties for his personal occupation. The fact is significant because unlike Minister Vivian's property, which was marketed through the SPIO portal, amongst others, the information given to Minister Shanmugam for his personal use by the Deputy Secretary would appear to have been privileged. At minimum, the man on the street would not have equal access to this information and would have had to secure it at some cost. So I would invite the senior minister to consider whether it would have been more appropriate for the minister in question to have engaged an agent to inquire about properties that are available for rental. How does the senior minister's report reconcile this with the Ministerial Code of Conduct and the Prime Minister's Rules of Prudence for PAP MPs, which requires that all ministers should scrupulously keep their official and private affairs separate? Should Singaporeans conclude that such actions by ministers as instructing civil servants on personal matters and using official information for personal use is appropriate, above board, and has been going on for a long time in the public service? My second bucket of questions pertains to reserves and land management, and I direct this at the Second Minister for Law. Senior Minister Teo's report is silent on why Minister Shanmugam did not have the confidence of the SLA, a statutory board that comes under his ministry's purview and the Second Minister's purview, in maintaining the adjacent land next to 26 Ridout Road, in spite of SLA being prepared to pay up to $25,000 a year for its upkeep. Can the minister explain if he probed, or I beg your pardon, can the senior minister explain if he probed into the substance of Minister Shanmugam's lack of confidence in a public service body under his charge? So, secondly, we've been told in this House, no less, that land is a very scarce commodity in Singapore, and it must be priced according to its market value. With SLA choosing to focus almost singularly on gross floor area and not total land area in its guide rent of black and white bungalows, including those in the most expensive and prime housing estates, comprising good-class bungalows, does this not represent a policy loophole that effectively is a special dispensation at the taxpayer's expense for individuals who can afford to rent black and white bungalows? The PAP routinely shuts down any proposal from the opposition or the public that draws down or is perceived to draw down revenue from state land as a raid on the reserves. SLA increased the size of 26 Ridout Road with prime land by almost 3 times, with no real impact on the cost of renting the property except for the usual maintenance. Does this episode not highlight a need to close this policy loophole and put a value on vacant land which IRAS anyway would tax a Singaporean for? To this end, can I ask the Second Minister for Law also to confirm, of the 600 black and white colonial bungalows in Singapore, how many have a total land area larger than 26 Ridout Road today? And how many lessees has SLA negotiated with to enlarge their compounds as much as was enlarged for 26 Ridout Road? These are my questions for now, Deputy Speaker.
SM Teo.
Yes, thank you, Mr. Deputy Speaker. Minister Edwin Tong has explained why, in the context of renting these properties, the gross floor area is of more significant importance than the total land area. I think, Mr. Pritam Singh, you will have heard that explanation, and I'm sure Mr. Edwin Tong will be happy to repeat that. And the reason is because when you rent the property, when you buy a property, you want the land, and the land belongs to you for the entire duration, whether it's a 999-year lease or freehold or whatever it is, or 99 years, and you can develop the property. It's worth something to you. When you rent the property for a short period of time, whether it's 2 years, 3 years, 9 years, you can't develop the property. And you have to maintain it. And I think Mr. Edwin Tong and Mr. Shanmugam himself have explained it. And in the valuation of the property by the valuers of SLA, they take this into account when assigning that valuation. And I should point out, as I said just now, that the SLA valuer did not know the rental amount which the leasing division had negotiated with the tenant, nor identity of the prospective tenant. So the valuer values the land based on the valuer's professional judgment. And I'm not one to second guess the professional judgment of a professional valuer. But let me give you some examples. The clearance of land is not unique to the case of number 26 Ridout Road. An example where SLA also cleared land to address these amenities is at a state property in Dalvey Estate in 2018. I referred to that in my statement earlier. The state property in Dalvey Estate had a significant amount of heavily vegetated land within the tenancy boundary. And in June 2018, the neighbors, as well as the tenant of the property, the neighbors living in nearby houses, raised persistent feedback on mosquitoes originating from this heavily vegetated area within the Dalvey Road estate property, which was tenanted out. SLA's managing agent carried out fogging in the area, but in spite of this, this did not resolve the problem. Having confirmed with NEA that the heavily vegetated land was indeed the source of the mosquitoes, SLA carried out partial site clearance of the vegetated area and created a 2-meter buffer to nearby properties. And with the agreement of the Dalvey estate property tenant, the fence line was in fact shifted inwards so that the SLA could take over the maintenance of the vegetated area. Based on the MA's account, I think the tenant was not unhappy about the smaller fenced-in area because he did not have to maintain the vegetated land. There was no reduction in rental as the MA's valuation was based mainly on the GFA of the house. And so this case illustrates the issues at hand. That added land is not always a net gain in value, and that some tenants may not be unhappy to reduce the land area to reduce the responsibility and the cost of maintenance. So I hope that adequately addresses Mr. Pritam Singh's question on that. On the issue of the addressing why Minister Shanmugam asked the Deputy Secretary, and I think Mr. Pritam Singh said, and this has been going on for a very long time, I think Mr. Pritam Singh should not make general comments like that unless he can back them up. I don't know, because that was a comment that you made, that it has been going on for a very long time. So I didn't understand what you meant by that, and if you don't recall having made that statement, I may appreciate it if you withdraw that. So Minister Shanmugam explained why he approached the Deputy Secretary, and as I had explained, this is not privileged information. Any credible tenant, any credible prospective tenant, and there are many examples of that, will ask for this information, can either access it directly or can get it. So this is not privileged information. And the issue of scarce commodity and land and so forth, I think Minister Edwin Tong has addressed that, and I think he will be happy to address that further if necessary. Mr. Speaker, I think that there are a number of different issues that can come up in today's discussion, but the central issue why we're here today actually is to deal with allegations of corruption, abuse of power, and conflict of interest. And there are other issues like how SLA manages state properties, or indeed whether there's equity issues and so forth. Perhaps these associated issues, we can deal with them subsequently. I'll be happy to answer them. But let us satisfy ourselves first on these issues of corruption, abuse of power, conflict of interest, as several of the members have asked. Let us satisfy ourselves on these issues, and then we can discuss the other associated issues. Thank you, Mr. Speaker.
Second Minister for Law, would you like to respond?
Mr. Singh asked me two questions. I'll address them. First, I think you said that, Mr. Singh said that the use of the GFA as being the main driver for rental and marketability of a property, and I think you used the word loophole. It's not a loophole. It is, when you say loophole, it suggests that it's a policy that has not been closed off, that for some reason, SLA chose to use GFA. I think if you heard my speech earlier, you'll see that this is a market-driven consideration. We can't set the policy and say, tell the valuers, just use GFA, ignore everything else, and expect that the market will adjust itself in a way which I've showed and I've explained. And I think the one real test of this is if you look at SM's report, and I know you have them on the portal. I didn't bring copies because you will recall an Annex D, and I invite members to pull it up from your portal. You look at the table says rental rates of black and whites across Singapore. So all black and whites across Singapore. And if you heard my speech earlier, you'll know that these black and whites are managed by SLA, as well as by external professional marketing agents. They're all industry experts for real estate. And I would add that more of SLA's black and whites are managed by external professional MAs than they are managed by SLA themselves. And these MAs have their own independent in-house expert valuers. And when you look at the table that is in SM's report, I think you will see that the benchmark, the criteria of using GFA as the determining factor for marketability and valuation of rental is, I think, made up. If you look at the table, you will see that at the time the rental was entered into, tenancy was entered into for number 26, and that's in 2018, 26,500 as the rental was the top 3 in all black and whites in Singapore. In 2019, it was the top 4. 2021, when it was renewed, it remained at the top 4. And throughout this period, per GFA, rental per GFA, throughout remained higher than the average right through for 26. So what was paid for 26 was within the top 3 in 2018, within the top 4 in 2019, all the way through to 2022, and remained on a per GFA basis higher than the average, right through. And I want to emphasize that these valuations at which the rents are transacted include being done by external MAs who are professional and industry experts. So it's not a policy that we set to say, let's just use the GFA to assess the value of these properties, and then there's a loophole somewhere where these properties are obtained on the cheap. They are not. If you look at Annex E1, and I invite Mr. Singh to look at it when he has some time subsequently, Mr. Singh will then see that the point I made about the average rental per square foot per month on an average basis, number 26 is at 30.94, and this is higher than the average of all black and whites in Singapore at 29.78. So I think we have to move away from the suggestion that somehow the methodology that's chosen was chosen to try and advantage some tenants. Now, In addition, you raised a point about the further land that was fenced in. I think you've heard Mr. Shanmugam explain this. You heard SM, you've seen CPIB's report, what was said about it. And you've also heard Mr. Shanmugam's instructions to his agent in relation to this additional land. It's not a land that can be enjoyed in a usual way as one might if you're the owner of a property with big land which you can develop as you like. And I think you heard me say earlier, the constraints, including on a tenant, and even if you are an owner of the land, the constraints if the property was conserved, as number 26 was and remains to be. The land was not something that this tenant wanted, but was concerned about the maintenance and offered to clear the land, and it was eventually at tenant's cost, and it was also maintained subsequently, prospectively, by the tenant at $25,000 per year. In addition, this land is not just fenced in on a willy-nilly basis. SLA had considered the reasons for doing so, why, what advantages SLA would have, like any reasonable, usual commercial landlord would. It takes into account the fact that this is a tenant coming in, making me this offer. The market is down, as I showed you. In fact, first quarter 2018, if you see my chart earlier, is probably at one of the lowest points. It's been vacant for almost 5 years. The previous tenant pre-terminated, and the previous tenant was paying a rent of $22,000 per month 5 years ago. Market has since moved down. This tenant is offering you $26,500. It's offering to maintain the land that otherwise SLA would have to maintain. Has said, I'm prepared not for this to be fenced in. I don't want it. But I will pay for the maintenance because we're concerned with health and safety issues, trees, mosquitoes, and so on. SLA's calculation then is to consider all of these factors, along with the fact that this tenant is also offering to put in enhancements to the tune of more than $500,000, as you heard Mr. Shanmugam, which are enhancements that the landlord will retain at the end of the period. And at the same time, help us to meet the conservation costs that the external consultant has assessed independently and calculated. So when you weigh up all these factors and take them into consideration, I think you can understand why SLA decided that, in fact, if we can get this tenant, it would be great, given the occupancy, given the market. But if you could additionally have this fenced in so that this becomes an obligation in the tenancy and not just something that could be terminable with notice in an option, as was suggested, that would improve SLA's position. And so overall, looking at all these factors and the piece of land in question, which abuts the neighbor, number 24, it sounds very big when you mention it in the way you have done, Mr. Singh, but it abuts the neighbor. It's relatively inaccessible. There are only a few access points, and there's not a common space where otherwise it could be parceled out and tenanted to another tenant. For many years prior to that, there was no monetization of that land by SLA. In fact, it was just a burden, had to maintain it. So when you consider all these factors and take them all into account, I think you will see why this was a transaction, as I said in my speech earlier, was something that was at arm's length, negotiated, commercial, and sought to achieve the state's interest as well. So I think you've got to look at it in that perspective when you talk about the land and throw the numbers around without the context of the sequence of events and the chronology of how the matters unfolded and the relative interests of the two parties, in particular, from my perspective, that of SLA, as we sought to protect SLA's interest and try and advance SLA's interest, at least in terms of the maintenance thereafter. Now, you asked a second question about why Minister Shanmugam had said he was not confident that the surrounding land would be properly maintained. You heard Minister Shanmugam earlier. He had offered through his agent to maintain this land at his own cost after it was cleared of the overgrown vegetation. SLA agreed to this clearance, did what it needed to do to address the health and safety concerns. There was from snakes, mosquitoes, and so on, and fallen trees, which I also mentioned. But since this is a reference to what Minister Shanmugam said, I will invite him to clarify his position on this.
Mr. K. Shanmugam.
Thank you, sir. Mr. Deputy Speaker, sir, if I may, if I can add on to Mr. Tong's clarification, I did not tell SLA that I was not confident about them maintaining the adjacent land. Based on my recollection, the essence of what I told SLA was that there are, they have many state properties across Singapore to manage. In comparison, I, as the prospective tenant of 26, would be able to give more attention to the adjacent land. It's right next to me. I also had an interest, specific interest in the proper upkeeping of the adjacent land. And any disamenities arising from it would affect me directly. So those were the reasons I gave to SLA. Now, behind that is my thinking, since they have to look after all of Singapore, my confidence in their ability to maintain that land in the way that I will maintain. I mean, it doesn't mean that, they will not maintain. But in any given context, when I'm maintaining it, one piece of property, it will always be different compared with someone who's got to manage all over Singapore. So I told that to CPIB, and that appears in CPIB's report. But I told SLA, you have all of Singapore to manage. I can manage this one property if you are willing. I know that it's a cost center for them, and it's a cost center for me, but I will be able to better manage. So that's the context in which I said to CPIB, I was not confident. So I think one has got to understand these contexts.
Mr. Zulkarnain Abdurrahim.
Thank you, Mr. Deputy Speaker. My first excuse to Senior Minister Teo. In SM's report, he concluded that Minister Shanmugam had declared the potential conflict of interest and removed himself from the chain of command. I would like to ask SM to comment on the Code of Conduct for Ministers, which speaks of an apparent and a perceived conflict of interest. And a minister should not be in a position where his financial interests might be even conceivably conflict with his public duty. So how should these standards be looked at in the light of Minister Shanmugam's case? Second SQ is a short SQ for Minister Shanmugam on his CPIB interview. I would like to ask Minister whether he was administered a caution when he attended at the CPIB for the interview. Thank you.
SM Teo.
Deputy Speaker, I'm quite conscious that I'm surrounded by lawyers and I'm not one myself, but I will try and explain on this issue of conflict of interest. On conflict of interest, Mr. Zulkarnain has referenced the Code of Conduct and asked essentially whether there's perceived potential or perceived conflict of interest in the case. Conflict of interest arises when two things coincide. When a person's duty, for example, a function or responsibility from the office or position that he occupies, conflicts with his own personal interests. So both of these elements have to exist. If there is one without the other, no conflict arises. So both have to exist. A conflict can be actual, which arises when a person, in fact, makes a decision on a matter where his duty and his personal interests in that matter remain. So his duty and his personal interests are there, and he made a decision in his capacity which affects his personal interest. Or it can be a potential conflict of interest which arises when a conflicted person is in a position to, but does not yet make such a decision. So that's a potential conflict of interest. And either of these scenarios have to depend on the specific facts of each case. A conflict is not a conflict just because of someone's perception of the facts. In my report, I found that there was the potential for a conflict of interest to arise, a potential. However, Minister Shanmugam identified this potential conflict of interest early, beforehand, and took steps to prevent it from actualizing. He removed himself from the chain of command and recused himself from any decision-making for the matter in question. He informed the Ministry of Law to clear any matters related to the tenancy if it arose with then SMS Indrani Raja and, if necessary, with myself. By removing himself from the chain of command, Minister Shanmugam took himself out of any decision-making responsibility in the matter. So he no longer had any duty in this matter, and therefore that factor disappears. Once there is a recusal, no duty arises. There can thus be no conflict. And I'm told by lawyers that the best way of dealing with any potential conflict of interest is to disclose the potential conflict and then proceed to recuse oneself altogether from the decision-making process. And this is what happened here on the facts of this case. Given the recusal and removal from duty, there can no longer be any potential conflict. Nor does a perception of conflict arise, and therefore there is no breach of the code of conduct. So when we talk about perception of conflict, once we are clear that potential conflict no longer exists, and we know that actual conflict did not exist, that should dispel the concept, the idea that there's a perception of conflict of interest in the minds of any fair-minded person.
Minister Shanmugam, would you like to respond to Mr. Zulkarnain?
Well, Deputy Speaker, sir. Yes, as I said in my earlier statement, they read out to me in Section 27 of the Prevention of the Corruption Act. And I think Section 27 caution was in these terms. Every person required by the director or any officer to give any information on any subject which it is the duty of the director or that officer to inquire into under this act, and which it is in his power to give, shall be legally bound to give that information. And I think a breach of it could expose you to a penalty of up to a year or $10,000 fine, year jail. Yes, this is a standard practice, and I'm sure Minister Vivian was administered too, but I certainly was administered. Thank you.
Mr. Louis Chua.
Thank you, Deputy Speaker. Just two clarifications for Second Minister of Law, Minister Edwin Tong. I think the first is in regarding to the issue of favourable rental rates and whether as a result of SLA's management of the renewal process as well as of black and white properties did this arise. I mean, I note that the property at number 31 Ridout was renewed in October 22 for 3 years with the rent increase from 220K from 19K. So this is about a 5% increase or so. But if we consider the market conditions, which I think Minister also spoke about in his speech just now, if we look at the URA private residential rents, I think that has increased by about 42% during the same period. And if we just zoom in on landed properties, it has increased by 35%. So, even if you look at HDB properties, I mean, just looking at the 4-room flats in Sengkang during the same period, the median rents have already increased by more than $1,000 in the same period as well, to about $3,000 a month. So I think this also comes in a period where I think the occupancies of the black and white houses as a whole, and as well as Ridout Road, have increased over this period of time, suggesting that actually specific to black and white, demand has also increased. The second clarification is in relation to the direct tenancy process. I think it's stated on the SLA's website that state properties are supposed to be let out through open tender to ensure the process is fair and transparent. So in this regard, I think I know that 31 Ridout was indeed on the SPIO website, but 26 was not. And I think in the May statement by the SLA, I think it was said that the Minister Shanmugam was the only bidder, and his bid through an agent was higher than the guide rent. I think subsequently, in response to CNA, one of the property agency's director for research even said that SLA properties are tendered out through a bidding process. So in this case, if for the SLA as a whole, when it comes to dealing with direct tenancy agreements rather than requiring a tender, would that then be amounting to something like a rate on the reserves again? Because if you look at how land sales are being processed by the URA, if there were a developer that wanted to bid
Mr.
on
Chua, kindly proceed
Sure,
to your
I'll
clarification. Your specific question on your second point, please.
Sure, yes. And so that's really the question, in that in not requiring a tender, but rather through direct tenancy agreements, if you compare the process of the SLA versus, say, how URA manages the land sales process, for example. Thank you.
Minister Edwin Tong.
Thank you, sir. Mr. Chua, the number 31 was managed by an external professional managing agent, which looked at the renewal and also did internal valuations independently to assess what the appropriate rental would be upon renewal. That's the process, and that was what was done, and the guide rent for the renewal was met, and that's why it was renewed. To your point about the movement of the market, if you were to just pick up the table I gave out earlier and look at the chart, renewal was done for 31 around the early part of 2022, first quarter. There were some discussions over the fact that there was some disamenity. I think there were some noise issues and so on. So the precise start date was subject to negotiations, but the discussions took place around this period. End of 2021, early 2022. And if you look at the chart that I have produced, this is the URA rental index. You will see that at that level, at that occasion, the rate was similar to when, if you look at the lines, horizontal lines across, similar to when the lease was entered into. So it roughly accounts for this. Now, beyond that, I think you also made the comparison with private detached homes, GCBs, and so on. I ask you to also bear in mind what I said earlier about these properties being intrinsically older. So leaving aside that they are spruced up and made habitable and so on, there's also a question of these fundamentally being older, not possessing the usual amenities and facilities that you might expect to see in a good class bungalow or a bungalow of this comparable size. So I think that accounts for the difference in the market. Whilst I appreciate the point you're making that right now, if you look at it today, there is a spike, and presumably that also has an impact on the rental market for black and whites, and that's true, because when we look at the performance of rental markets, rentals for black and whites today, now, it is obviously very different from when it was in 2018, 2019, and so on. And you must bear in mind also that in 2021, 2022, there was still the COVID overhang over the market at that point in time. So these are factors that really, I'm not a property agent and I'm not a real estate expert, but I go back to the first point I made to you, which is this is looked at by an external professional managing agent. In this case, it was Colliers, which managed the renewal, and they have their own in-house expert valuers, and I wouldn't second guess that. Your second point about whether it's I think in your words, a raid on the reserves because we do direct tenancy and not a tender process. I think I explained that in some detail. You have to adopt a method that coheres with the market, with the movement of the market. If the market is on its uptrend, there's a lot of demand with limited supply, then I think you want to make sure that you put it out as much as you can, as publicly as you can, so that there is a really big showing of the properties on offer that is being supplied, so that the demand can match up with the supply. But when you have the converse situation in a falling market or the softening market or a more depressed market, then you might end up with a situation where having more or listing everything will mean that you are simply competing against yourself. There are many more options than the demand meets. So you have to attenuate based on that. And that's also something that not just SLA does, but also the managing agents that are engaged by SLA, that's how they also approach the issue. And that's what they do as well. That's not to say that because it is not on SPIO, that it is not marketed. You seem to suggest that because it is not on SPIO, therefore it's less exposed. But remember I said that each of these agents also have their own property portals. And in fact, the property portals will be shared amongst the real estate agents. When they come in, if you make a serious inquiry, an agent who is familiar with this aspect of the market, this segment of the market, will know where to access the information. You might see one or two on SPIO that you might want to have a view, but when you get there and you talk to the agents, and if you're a serious prospect for tenancy, this agent will have access to others. So it's in a softer market, that's how it's done. And that's the position that's been taken not just by SLA, but also by its managing agents.
Ms. Nadia Samdin.
Thank you, Deputy Speaker, and I thank each of the ministers for addressing the questions raised, including those which affect their personal and public lives. I would like to follow up on Second Minister for Law, Mr. Edwin Tong's statement relating to SLA's processes, in particular the preparatory works for the rental of the two properties and ongoing maintenance for black and whites. Can I clarify how SLA scopes and awards contracts to different entities, from consultants to contractors, for the restoration and maintenance works for both categories of black and whites? For example, is there a pool of pre-approved vendors? What is the process by which SLA designates what works will be borne by SLA and which works will then be at the tenant's own cost? I would also appreciate particularly if the Minister can address allegations that the contract for works relating to the properties were awarded to a firm of which Minister Shanmugam's son serves as CEO, called LiveSpace. Thank you.
Minister Edwin Tong.
Yes. I thank Ms. Samdin for the question. As I explained earlier, we put in place a system where an external consultant is engaged to study and have regard to the conservation guidelines and study the state of the property and make recommendations to SLA as to what works needed to be carried out and also how they need to be carried out given the conservation guidelines. So this is external to SLA. They are consultants and they make a recommendation to us. After that is done, as I said, we time it such that we try not to disrupt the existing tenancy if there's a tenant that's in place occupying the premises. And we also try and time it such that once this is done, there's a greater prospect of a confirmed tenancy so that the rental income stream can then be used to meet the cost of these works that have to be done. And that was what was done in 26. And when the works are confirmed and we accept the recommendations of the consultant, the works are then carried out by a separate contractor, not the consultant. And in this case, what happened was we put out an open tender and a term contractor was then appointed to carry out the works. In addition, there was also an appointment of a conservation specialist to advise on certain aspects to cohere with the conservation guidelines. The suggestion that Minister Shanmugam's son or his company, LiveSpace, was appointed, and I think the sting of these allegations is that there's a preference given to this, is completely scurrilous and unwarranted. There is no basis to suggest that. For both 26 and 31, the works that were recommended by the consultant was then done and awarded to a contractor through a tender, and LiveSpace was not an appointed contractor. Neither did they have any transactions with SLA, as far as we can tell from the quick checks that we've done since these allegations began to surface online.
Ms. Hazel Pua.
Deputy Speaker, sir, since this relates to me in a way, can
Yes.
I be permitted to add to this?
Yes, please.
I mean, inevitably, there were and are many untruths circulated about me, my rentals. Inevitable because I'm a political figure and obviously a target. For example, that falsehood that SLA had built a car porch for me, or that I had cut down trees illegally, or that I'm paying less than market value, or the innuendos, some of which we heard in Parliament, about land being added as if it's a special favor, even though I didn't, the facts show that I didn't want it. And I explain why. It's a cost center. The CPIB has established these and other allegations to be untrue. But I've not been the only one attacked. My son has also been attacked. Allegations online that the contract to renovate the Ridout properties, in plural, was awarded by SLA to a company where my son is the CEO. I don't keep track of SLA's contracts. There are established processes for the awarding of contracts by statutory boards. My son tells me that his company does not have any contracts with SLA, nor did they do any work on the Ridout properties for SLA. You get these utterly false and defamatory statements. Do these people really believe that CPIB would not have found this out if it were true? I say to these people, you want to come after me, you come after me. I'm perfectly capable of defending myself, and they will find out that I will defend myself. But leave my family alone. This is how some conduct politics. Try and make it difficult or impossible for family members or people who are prepared to come into public service by putting out deliberately false information. Thank you, Mr. Deputy Speaker, sir.
Ms. Hazel Pua.
Thank you, Deputy Speaker. My question relates to the site clearance in the land adjacent to 26 Ridout Road. The SMTO mentioned earlier, quoting another example of site clearance at Delvey Estate, and said that it was for a 2-meter buffer. But the site clearance at the land adjacent to 26 Ridout Road is actually 150,000 square feet, if I'm not wrong. So the size of the two are actually quite different and seem like overkill. So my question is, are there any other site clearance to the scale of 150,000 square feet? And secondly, the notion, while I accept that the rental will be more based on the gross floor area than empty land area, but it is a bit difficult to accept that the large empty extra land that is added into the boundaries of 26 Ridout Road is put at zero value. So my question is, was the valuer specifically asked to value that piece of empty land as well, or is it simply a case of valuing the original 26 Ridout Road at 24,500 and plus the recovery of site clearing costs at 2,000 per month only? Thank you.
Mr. Deputy Speaker, I cited the case of the land at the tenancy at Delvey Estate, not so much to compare the area of the land, but to make the point that having more land is not always an advantage. In that case, the tenant of the Dalvey Estate property was not unhappy that his land area was actually reduced. There was no reduction in land, and he was actually not unhappy that the fence line was moved in. His land area in the tenancy of the property was reduced, and SLA actually took over the maintenance of the land which would otherwise have been within his property. So that was the point I was making, and I think Ms. Hazel Pua may have missed my point, but I make it again. Second, on the valuation of the property. The valuation of the property is done by professional valuers, and I will not second guess their valuation. And the valuation, the valuer in SLA was asked, what is the valuation of the property with the inclusion of the additional land cleared? And the valuation that was given by the valuer was $26,500. So that is the professional valuation from the professional valuer.
Dr. Tan Wu Meng.
I thank the ministers for their ministerial statements. I have a clarification to put to the senior minister. The financial sector and banks have a category called politically exposed persons. Depending on jurisdiction, it can include ministers, members of parliament, leaders of political parties of any persuasion, and their immediate family members. Should the public service consider having a framework whereby the personal transactions of politically exposed persons with government agencies be automatically flagged up for additional scrutiny? This helps further ensure the public officers are in the clear, protects the public officers from allegations of malfeasance, and it also helps ensure the politically exposed person is in the clear as well, regardless of their political persuasion.
I thank the member, Mr. Deputy Speaker, for his suggestion. Financial regulators require banks to apply enhanced customer due diligence on customers that are identified to be politically exposed persons. I have a lot of difficulty opening a bank account in another country. Banking transactions can involve, and this is the reason, because banking transactions can involve the transfer of substantial funds that flow rapidly and many times, even in a day or in an hour, across borders from multiple sources to multiple destinations. So the banks are therefore required to know their customers, KYC, and exercise vigilance to flag suspicious transactions so as to prevent money laundering and terrorism financing. Those are the two principal reasons why the politically exposed persons framework has been established for financial institutions. The considerations, sir, are different for transactions by political office holders and public officers with public service agencies. A potential conflict of interest can arise in a transaction with a government agency, but also in making a policy or an administrative decision. So there may have been no transaction, but a public officer or a political office holder may be making a policy which impacts him. Or in a transaction by persons in political office or in the civil service with non-public sector organizations. And given the context of the work of public agencies, a number of measures have already been put in place. For key transactions, especially transactions that involve public tenders and the evaluation and award of major projects, there are already processes for public officers to declare conflict of interest upfront. For public sector transactions, there are suitability checks carried out on the counterparty, even in this case, for the rental of state properties. And there were suitability checks carried out on the prospective tenant. The public service also has an internal disclosure policy. An officer is required to report any wrongful practice to the head of his agency, even if he has been instructed by his superior not to do so. So he is required to report any wrongful practice that he comes across. There will be an investigation into the allegations, and what we conventionally call the whistleblower will be protected if he has made the report in good faith. So there are multiple measures in place, and it's quite different from the very rapid transactions that can take place, transfer of funds in a bank. And that's why the banks require a PEP type of system upfront. I should also point out that the types of checks at the agency level are only part of the system and actually don't address the fundamental issue at hand. And the fundamental issue at hand is that the onus still rests on the individual to declare and recuse himself to prevent a conflict of interest from arising. So even if checks and processes by the public sector organization do not flag a conflict of interest, the individual still remains responsible and will be held accountable if he is subsequently found to have a conflict of interest, abused his powers, or improperly made use of privileged information. The public service will continue to reference the best practices in other sectors, such as the financial sector, to keep improving its system of governance. For example, once a year, officers in positions of authority over funds and so forth have to take leave, and somebody else takes his place. So the public sector has rules where persons in such financially sensitive positions can't stay in that position sort of indefinitely. They have to be rotated, and these are some of the rules that are in place. And I mentioned to you that PSD is working with relevant ministries to see how we can implement declarations specifically on rental transactions, and PMO will look at that as well. But these are examples which add to the guidelines. But the general principle still applies all the time.
Ms. Sylvia Lim.
Thank you, Deputy Speaker. I have a clarification for Senior Minister Teo on the standards expected of our ministers. I must say that I find it disappointing that he reduces the issue of conflict of interest into a legal argument. I mean, in the Code of Conduct for Ministers, it's stated quite clearly at the bottom of the document that the document does not have the force of law, and whether there's a breach or not is not justiciable in a court of law. So does he agree with me that actually the Code of Conduct embodies the highest standards expected of our ministers in their conduct of their public affairs, and it should not be the subject of legal arguments or technicalities? The second clarification on a related point is, if one looks at para 3.2 of the Code of Conduct, it is stated very strictly, a minister therefore must never enter into any transactions where his private financial interests might, even conceivably, come into conflict with his public duty. So that is what is stated there. Never enter into transactions where his financial interests might conceivably come into conflict with his public duty. So does he agree that it might be reasonable to interpret this to mean that actually the law minister should not have entered into this transaction with the SLA, which is an agency under his charge, or at the very least, it was imprudent of him to do so?
Mr. Speaker, sir, Ms. Sylvia Lim is a lawyer as well. I explained to another lawyer earlier, Mr. Zulkarnain, what conflict of interest means. two things must come together at the same time. And this is not a legal description. It also underpins what the understanding of conflict of interest is in the code of conduct. There must be some official power that you have over some matter, and that matter coincides with a personal interest of that person. Those two things must come together. There's an actual conflict of interest if the person with that duty, with those powers, uses them on a matter in which he has a personal interest. There's a potential conflict of interest if that person retains that power and there's a matter which is there, which is his personal interest, but no decision or action has yet been taken by that person. So that is removed. The potential conflict of interest is removed if the person removes himself from that duty. Ms. Sylvia Lim is a lawyer. I think she understands that. And so that is the import of what conflict of interest is about. And Mr. Shanmugam took steps to make sure that he removed himself from those duties and powers that he had over a matter which would have been a private matter, and therefore the two were separated. And one of those two factors which must exist for conflict interest to arise, which is that the person must have powers over that private matter, was removed. So that's very important. And I explained that earlier, and I hope that that will satisfy Ms. Sylvia Lim. And as I said, there are perceptions. But once the actual conflict of interest and the potential conflict of interest have been removed, that should dispel the perception of conflict of interest in any fair-minded person.
Mr. Xie Yao Chen.
Thank you, Deputy Speaker. I have 2 points of clarification. First, on the clearing of the adjacent land at 26 Ridout, I'd like to ask how many trees were actually cleared? And did the review by SMTO look into not just SLAs, but MParks as an involved agency, MParks process to determine the removal of trees, which trees were removed, etc. And most crucially, the MParks know the identity of the prospective tenant in the course of this process. Second, on land management, I'd like to ask how much land in total, what is the total land area that state-owned portfolio of black and whites actually sit on? And how might this factor into the government's weighing of economic and social factors to determine how best to use the land and manage a portfolio of bungalows? Thank you.
I'm sure Minister Edwin Tong would like to reply, but this is an issue of land management. As I said earlier, I think we should clear the core issue first, which is whether there was corruption, abuse of power, or conflict of interest. And that's the reason why we're here today. And we should clear those issues, and if any members have any clarifications or questions on those issues, I'll be happy to take them.
So, Minister Edwin Tong, you are going to respond to that later, I understand. Yes. Mr. Leon Pereira.
Thank you, Mr. Deputy Speaker. I thank the ministers for their statements. My first SQ is really on the determination that the conduct of the ministers in this case is consistent with the Ministerial Code of Conduct. Why was that determination not passed to an independent third party to make. For example, the Auditor General's office, or for example, an independent judge. I'm not asserting that SMTO's review is not independent, but I think the perception that that judgment, that determination was being made by someone who is not a senior colleague of the ministers concerned, but is an independent entity, would go some way to address some of these public concerns. And the Auditor General does have expertise in understanding norms of best practice within the public service, norms of corporate governance, audit compliance, and so on and so forth. And I would note, Mr. Deputy Speaker, sir, that in reply to a PQ I filed, there have been 2 occasions when the Auditor General was asked to do a special audit in the last 20 years. The first occasion was to interrogate the claims made by an opposition leader, Mr. Chee Soon-juan, in the 90s. Second occasion was to investigate the finances of Aljunied Hougang Town Council. So why couldn't the Auditor General have been called in to make that determination, not of corruption? You know, I appreciate the work of the CPIB. CPIB's expertise is Prevention of Corruption Act, but to make the determination about consistency with the Ministerial Code of Conduct. Second one, I want to come back to para 40 of the report, Minister Shanmugam requesting the information about some of the black and white bungalows from the DS admin law. And I'm trying to understand how this is not problematic, because based on the report, SLA has explained that there is a deliberate policy intent here that in certain times, like a down market cycle, the deliberate intent is not to make too transparent all of these listings, which is why 26 Ridout Road was not listed on the SPIO. It's not by accident. If I can just read very briefly from a Straits Times article that talks about why SLA has this policy. When market conditions are poor and supply exceeds demand and the occupancy rates for specific estates are low, publishing complete listings of all vacant properties online would result in these properties visibly competing for the limited demand, and thus may not help the landlord maximize outcomes. So in this case, how is the action of the Law Minister to ask for information on properties, some of which are not listed on the SPIO, into one simple consolidated fact sheet? How is that not problematic? And lastly, on the methodology, to choose a methodology of direct tenancy negotiation versus open bidding, I understand from Minister Tong's statement earlier that direct tenancy is...
Mr. Leon Pereira, perhaps we can take that later because we want to clear the more fundamental issues first.
All right.
Mr. Speaker, sir, I appreciate, I didn't want to bring up the issue of when the Auditor General had to be called in to look into issues, and you were the one who brought it up. I didn't want to bring up that history and link the two. But since you have, I may have some comments on that as well. Why not the Auditor General and why the CPIB? So the Auditor General looks at things which have got to do with audit. Was there misappropriation of funds? Was there loss of funds because of somebody not doing the accounts properly and so on? That is the Auditor General's function. To ask the Auditor General to comment on whether or not the practices were in line with the Code of Conduct for Ministers, I think goes beyond the ambit of the Auditor General. I think eventually the government, the Prime Minister, has to take responsibility for that. And we are. Why do we call in the CPIB and not the Auditor General? Because the CPIB is the agency which investigates such matters. And we know the reputation of the CPIB. It is a very thorough, it is a very independent agency, and as I said just now, it can be quite a fearsome agency. And the fact that the Prime Minister called in the CPIB to carry out this investigation on 2 senior ministers shows the seriousness with which this government and the Prime Minister took this issue. I suppose, Mr. Speaker, sir, if we had called in the Auditor General, Mr. Pereira would have been asking me, standing up, asking me, why didn't you call in the CPIB? Since the CPIB is the most appropriate agency to investigate such an issue. So, I think that underlying a number of these questions are a couple of things. And this idea that there's some secret list somewhere which nobody knows about, and that renting such properties confers some benefit or privilege which others cannot access. So I think the investigation and what I've stated and what Mr. Edwin Tong has stated refutes both of these, dispels both of these. First of all, there's no secret list. It's public information what properties are available for lease. SLA wants to maximize the renting out of these properties and to do its best for the state in doing so. So there's no reason for SLA not to want to provide those properties and the list of those properties. Mr. Pritam Singh earlier talked about individuals having to go to considerable expense to find out and so on. Actually, they don't have to. In the case of the company that I talked about, they didn't have to pay anybody to get the list. They asked SLA, and SLA was quite happy to give it to them without charging them, because SLA wants to rent out its properties. So there is no secret list. It may not be on the SPIO, but any credible tenant who wants to rent those properties will know which properties are available. And second, the properties are rented out at market. And so there is no great benefit from being able to rent out these properties. So let us dispel these two things and put it to rest. Although Mr. Pereira does bring it up, but I thank him so that I can explain these things quite clearly. So I think I've addressed Mr. Pereira's points.
Ms. Polisan.
Thank you, Mr. Deputy Speaker. I have two questions. Notwithstanding the findings that both ministers were clear of any wrongdoing, the revelations of the report have since raised more concerns from the public. So the first question is for Minister Edwin Tong. For 26 Ridout Road, which had only attracted one bid, did SLA not solicit additional bids after the extensive refurbishment was completed, just to test if the price was still a fair market price? And my second question is for Minister Shanmugam and Minister Vivian. The Minister's Code of Conduct clearly mandates that Minister must scrupulously avoid any actual or apparent conflict of interest between the official duties and private financial interest. So it is in the interest of transparency that both ministers declare all their property assets. If there are any, will the two ministers declare if these properties have been rented out any time during the lease of 26 and 31 Ridout Road to assure the public that there is no monetary gains from lease arbitration? Thank you.
Yes, SM.
Sorry.
Yes, please proceed.
On Ms. Polisan's second question, there is no requirement today for, under the Code of Conduct, for the type of declarations that she's talking about. And I did mention what the Code of Conduct does say and what it covers. I'll leave the rest of the questions to Mr. Edwin Tong.
To Ms. Po's first question, the property remains on the market until the lease is signed and confirmed. So at any point in time, up till the time when it is off the market, that is when the tenant confirms his tenancy, it continues to be marketed. So to answer your question, whether before, during, or even after, as long as the incoming tenant has not confirmed, it remains on the market and it will be marketed by the agents.
Ms. Herting Rue.
One clarification for Senior Minister Teo.
Senior Minister Teo stated that he was not within the chain of command in making the decision. Therefore, he was not involved in the matter, and therefore he headed this review. SM Teo also mentioned earlier that he relied on the independent CPIB report. However, when the declaration was made to him back then, and SM Teo was made aware of this matter, I assumed that he was already satisfied then that all actual or potential conflicts of interest were satisfactorily addressed back then, and therefore the matter was put to rest at the time. Otherwise, he would have voiced his concerns at that time. Given the public interest in the matter and the importance of public perception that there was no wrongdoing, what was the reasoning behind asking SM Teo to investigate the matter this round? Were there really no other options or individuals who could have led the review? After all, CPIB usually looks at whether there have been any breaches of criminal laws, which they have investigated here and cleared the ministers of doing. The review headed by SM Teo would also need to go beyond criminal matters, including looking at whether there have been any breaches of ministerial code of conduct or the rules of prudence, and also about the perception and the conflicts. I ask again because if SM Teo had been satisfied back then that any actual or potential conflicts of interest were actually addressed satisfactorily, it seems strange to ask him to now relook his earlier conclusion that everything was adequately addressed. Furthermore, apart from relying on the CPIB report, and given the questions raised they actually go beyond criminal matters, were there any other specific steps that were taken to ensure that there was adequate independence throughout the review? Thank you.
Mr. Speaker, sir, I think I've already explained my position. Mr. Shanmugam told me what he was going to do, and I accepted that. I did not approve his rental. I did not take part in any of the transactions. As I explained, Mr. Deputy Speaker, this is similar if you had a situation where you have a chairman of a company or an organization, and a director comes to him and says, I have a conflict of interest, I'm declaring it, and I'm taking steps to make sure the conflict of interest doesn't arise. Subsequently, it's discovered or it's alleged that that director had a conflict of interest. It doesn't preclude the chairman from convening a disciplinary committee or even sitting on it, because unless he was a participant in the actions of that director which resulted in the conflict of interest. So that's the situation that I'm in. It's very different if you had an organization in which convenes a disciplinary committee, and the persons who convene the disciplinary committee take part in the disciplinary committee themselves and are involved parties. That's a conflict of interest. So I think one must differentiate the two situations. And I hope that Ms. He is able to do that.
Mr. Dennis Tan.
Thank the ministers for your answers. A seeking clarification from the senior minister. I know senior minister explained to the other MPs' queries. I come back to this point on the Minister Shanmugam's asking the Deputy Secretary for a list of the property. And I've been trying to understand senior minister's explanation, and I find that there are still issues that we need to overcome here. And let me put it in a certain way, and then I can put the question to you. And because we are talking about a minister who is asking a deputy secretary in his ministry a question relating to his private interests, not in the course of his work, and the minister and then on the part of the DS had to. I think there's an issue whether the DS had to decide whether this is a matter of work, and if it's a matter of work within his responsibility, Is it contingent on him to answer? Is it appropriate for him to answer this question? I don't think these issues have been adequately clarified. It is important we clarify this as a matter of guidance for the civil service, all right? Because the civil servants, the senior civil servants must know where the line is drawn. For example, in this issue, Senior Minister, in this issue, the DS could have politely informed Minister Shanmugam that he can get his agent to direct the question to SLA. That, I think, would be an appropriate, in my view, a form of appropriate form of answer rather than to take it upon himself. So I would like to ask the Senior Minister to reconsider your answers, your earlier answers, in light of the issues I have raised, because it pertains to, I think it's important for the future. When a civil servant, a senior civil servant, or a civil servant has to answer a question from an office holder, what he's entitled to do, what he should do. So thank you, Senior Minister.
Yes, I thank Mr. Dennis Tan for his question because it is an important question. But the key issue here is, was there privileged information that the minister was seeking? And was there privileged information that he was trying to obtain? And so I think the key issue here is that there was none. There was no privileged information that the minister was seeking to obtain. And Minister Shanmugam explained in his own terms why he decided to approach the Deputy Secretary, because he was doing this in an open, transparent way to tell his ministry, I'm doing this, there's no secret about it. I mean, he could have got an agent and go and approach the SLA, and then later on SLA discovers that actually the minister was behind it. Is that better or is that worse? I think it's a judgment. And in this case, I think the minister told his ministry and was quite open and transparent about it. And if he had got an agent to go and approach SLA, and then SLA provides information or whatever it is, and then in the end they discover that actually the person behind it was the minister, and the minister didn't say anything about it, the question is whether that's better or worse. But in this case, it was done openly and transparently. So I think that is important. Second, as I said, was there privileged information that was asked for? And the answer is no. So I think those are the principal issues at hand.
We're still on conflict of interest theme. Minister Shanmugam, you'd like to respond?
Yes, in specific answer to Mr. Dennis Tan, SM answered, I think I explained in some detail why specifically the Deputy Secretary, and you heard the Senior Minister. What was in my mind is I should let Ministry of Law know, because that way the Permanent Secretary will know, the Deputy Secretary will know. These are senior admin service officers. I could have written direct to SLA, or I could have asked my agent to write direct to SLA, and I know based on practice, they do give this information. And I explained why I thought that it's better to ask the Deputy Secretary. It was a judgment call. It's better to ask the Deputy Secretary rather than going direct to SLA. If I had gone direct to SLA and SLA receives a letter, is that better? Or is it better that, there is the Deputy Secretary who, together with the Permanent Secretary, knows that this is happening, gets a list, and I look at it, and then I recuse myself if I want to proceed. So everything is transparent, above board, and I think it was important for me to have told my ministry. So this is not on a private errand or something. I looked at it as I'm telling my ministry and saying, I think it's, I didn't express it, but that is the understanding. They understood me and I understood my thinking, which is, If I ask you, you get it, I look at it, that way the ministry knows what I'm doing, rather than writing directly. And I see that as something that is entirely proper.
SM Teo Chien.
Thank you, Mr. Deputy Speaker. I thought I should make a clarification on something I had just said, which my colleague said may possibly be misunderstood. I had earlier said that it is important to observe the spirit rather than the letter of the codes. I think that is open to serious misinterpretation. What I meant was it is important to observe the spirit rather than to just, and not just, the letter of the codes. And I think if you look at the context of what I was saying, you will appreciate the context, because there are many examples that are given. You may just follow the examples, but if you don't follow the spirit, that's not good enough. So you must follow the letter of the code, but that's not good enough. You must follow the spirit as well. And I thought I should clarify that in case it's taken out of context.
Yes. Mr. Gerald Giam.
Thank you, Mr. Deputy Speaker. I have questions for Minister Shanmugam as well as SM Teo. Why, Mr. Deputy Speaker, why couldn't Minister Shan inform his Permanent Secretary separately after getting his agent to make the inquiries? And did he make clear to his DS at the time that he asked him that he was making this request for the purpose of transparency? To SM Teo, does SM Teo think that as long as no privileged information is asked for, a minister can make a personal request of a civil servant relating to transactions under his ministry? And does he think that other ministers should do the same in future when faced with a similar situation as Minister Shanmugam? Thank you.
So I think this is one case where Mr. Giam is obviously taking what I said out of context.
Minister Shanmugam.
Deputy Speaker, sir, can I have Mr. Giam's question again, please? Thank you.
Mr. Giam.
So why couldn't Minister Shanmugam inform his permanent secretary separately after getting an agent to make inquiries? Because we discussed earlier that he could have asked SLA through an agent, but he chose not to. He chose to go to his DS instead. Why couldn't he go to his agent, get his agent to ask SLA a question, and then inform his PermSec separately? And did he make clear to his DS at the time that he was asking him that he was asking for the purpose of transparency?
I thought I've explained this a number of times. When an agent goes and asks SLA, SLA will ask, who are you asking for? They're not just going to give it to every agent. There must be a principle identified. I did say, in my understanding, the person who is asking has got to be a credible prospect. So who is asking? And the agent will then say it's Minister K. Shanmugam. And as I said to Mr. Denistan, is that better? Or is it better to ask a much more senior officer and let him know? Now, as to whether I told the Deputy Secretary that this is in the interest of transparency, I think the context was clear because he told me, if I recall correctly, that he will keep the Permanent Secretary informed. So everybody understood. Yes, this is why I'm asking him. He will keep the Permanent Secretary informed, and he will get me a list, and then we see how we proceed, rather than going direct to SLA. Thank you, sir.
I see three more new hands. I'll take the 3 hands on this theme and then also open the floor to the other theme, which Mr. Xie Yao Chen had raised, which Minister Edwin Tong would like to respond to. And also, I think Mr. Leon Pereira had a third supplementary question to Mr. Tong. So the three hands are Associate Professor Lim, Mr. Leong Man Wai, and then Mr. Pritam Singh. And then we'll go on to a different theme. So if I could ask the three members to stay on theme. Thank you.
Thank you, Mr. Deputy Speaker. So my question in this particular theme is very much in the spirit of this question. And I understand from the report that, and the statements made, that there were no actual or verifiable conflicts of interest in the Ridout transactions made by the two ministers. That said, Mr. Deputy Speaker, I would like to hear directly from the two ministers, Shanmugam and Balakrishnan, if on hindsight, whether there are specific actions that they undertook that they now believe, at the very least, could be perceived as a conflict of interest, keeping in mind that we operate as public servants and perceptions are very important for public figures, and especially since the Ministerial Code of Conduct, of course, includes this more stringent qualification. I have a second question, but I'll leave it for a subsequent theme.
I thank Mr. Lim for this question. I think it's an important question, and it's at the heart of a lot of misunderstanding, even from lawyers. Actual conflict. I think I'm glad to hear Mr. Lim and others agree there is no actual conflict. But just so that we understand what it means, actual conflict is you have an interest and you make a decision. We all agree that wasn't there. From what I hear from the members, there was no potential conflict either, because I recused myself. Potential conflict, as I explained, arises when you have an interest and you may potentially make a decision. Members agree from what they are saying that there was no potential conflict. They accept the conclusions of the reports on that. The confusion arises on perceived conflict. And let me explain what is at the heart of the confusion. When you talk about conflict, what are you talking about? You are talking about someone in conflict. There is an interest on one side and there is a duty on the other side. If one of those don't exist, there is no conflict. If there is no actual conflict, no potential conflict, what does perceived conflict in this context mean? It seems to me, in essence, the essence of Mr. Lim's questions and some of the other questions, including Ms. Lim's question, is that if others perceive you to be in conflict, therefore you are in conflict, and therefore you are in breach of the ministerial code. It doesn't matter that you took no part in it. It doesn't matter that you recused yourself. It doesn't matter that the matter was decided perfectly properly. As long as a member of the public or anyone else can take the view that you are in perceived conflict, you are in conflict. Now, you can't run any government on that basis. Let me give you some examples. Minister for Health goes to a hospital for knee replacement. The hypothetical example. He goes to a hospital, knee replacement. He is not in actual conflict. He is not asking them to charge him anything less. Otherwise, Prime Minister will ask CPIB to look at it. He is not bringing forward his surgery ahead of others against medical advice. That could be abuse of power. But someone can say, you are the Minister of Health. You appoint or you have a say in appointing the CEOs. You are the person who decides on the structure and in some ways, their career progress. They might treat you better than they might treat others, and therefore you are in perceived conflict. Can a government work on this basis, that it's entirely up to a subjective viewpoint on perception, perceived conflict? Or Minister for Home Affairs, in a personal capacity, goes to file a police report. Can someone say, well, that creates a perceived conflict of interest because you are in charge, ultimately, of the police force, and they might, therefore handle the investigations differently, and therefore there is a perception of conflict. In anything dealing with that report, the minister must recuse himself. He must have no part to play. He must treat himself as a private citizen, and the matter must be handled by others appropriate within the police and the ministry. I can give you a string of examples. Minister for Education, his son applies to a school which has some discretion whether to admit children or not. Is he in a perceived conflict of interest? No, I thought about it. The reason why we are ranked as highly as we are, and the reason why this government is not corrupt, is because we take these things seriously. Ministerial code of conduct doesn't mean you get to absurd results. It's got to have common sense, it's got to be the spirit, it's got to be the letter, and it's got to be applied sensibly and properly, but rigorously. What is the perceived conflict? Can someone explain to me? Rather than just repeating the word, what is the perceived conflict? I mean, in essence, strip it of all these legalese that people use. In essence, what is being said is, if you are in charge of a ministry, you must not engage in any transaction which is available to public citizens. That's in essence what's being said. If that is so, that's a new principle. Because some people may perceive you to be in conflict. But that's not the principle in the code. That's my answer to Mr. Lim. Thank you, Mr. Deputy Speaker.
Mr. Leong Man Wai. Mr. Leong. Oh. You have a clarification, right? Do you, or do you not?
I do, yes. So just the clarification is that for Minister Shanmugam, on hindsight, that there are no perceived conflicts of interest in his mind that he would have otherwise corrected.
Sorry, sir, I missed part of Mr. Lim's question, so maybe if you can repeat it again.
Yes, it is that in your mind, there are no indeed perceived conflicts of interest on hindsight that you would otherwise have alternatively acted in a different way.
In my mind, there was a possibility of a potential or perceived conflict of interest. I didn't think there was going to be any actual conflict of interest because, as I said, rentals don't come up to Ministry of Law. But there is a potential conflict of interest if I remain in the chain of command. So that was very much in my mind, which is why I went and took this step. And the way this government operates, Senior Minister Teo, previously in charge of the Public Service Division, knows all about how our rules operate. And that is why I went to him and said, if this comes up, can Indrani come to you? In fact, I could have left it with Indrani. Our people are honorable, competent. Indrani could have dealt with it herself. But I didn't even want to take that chance. I wanted to make sure that there was somebody more senior than me who can have a say in the matter if it came up. So yes, the answer is yes, it was in my mind, which is why I took the steps that I took.
Mr. Leong Man Wai.
Thanks, Deputy Speaker. I have two questions. One for the, both for the SM. But before that, what I'd like to say is that I think what we are discussing today is that most of us believe in the integrity of our government. But what we are trying to establish is that are there conflicted situations that we should avoid going forward? And then from this, if we agree that there are some conflicted situations, whether the outcome of the terms and conditions of the contract reflect that, or whether the terms and conditions reflect a conflicted situation or not. So we actually still in the process of discussing and debating, and I hope the SM will be patient, that we probably cannot conclude whether there's a conflicted situation or not. But first of all, now we are talking about whether there's a conflicted situation or not. So maybe I have two questions I'd like to ask. Is one, the SM himself said, if someone has the power over his personal interest, then it may potentially be a conflicted situation. So if, although the law minister have explained that it may not be a conflicted situation, although the CEO of SLA reports directly to him, but his personal interest is affected, can be affected by the decision of the CEO of SLA, who reports to the law minister. So indirectly, the law minister, although recusing for himself from the decision-making process, has power over his personal interest. What do you think about this? First question. Second question is regards to the code of conduct. I think the SM just now mentioned that it should not just be the letter of the code of conduct, but also the spirit. But we expect our government to be a government of integrity. Don't you think that our expectations and the expectations of many Singaporeans would be you don't touch anything that you are doubtful? So if, can I ask, the SM, if under the current situation, don't you think the two ministers should have considered the possibility of negative public perception? Because the Singaporeans are already saying the ministers are paid $1 million of salaries, the ministers have private bungalows of their own, and they still go and rent a relatively cheaper public bungalow, which, however, are the three most prestigious bungalows in Singapore, and having the government to fork out over $1 million to reinstate the bungalows before they move in. Don't you think that that scenario conjures up a very bad picture? Thank you.
Thank you. Mr. Speaker, I would like to thank Mr. Leong for his emphatic belief in the integrity of our government. Sir, on the issue of conflict of interest, I think we have spent quite a lot of time explaining what needs to be there for a conflict of interest to take place. And that Minister Vivian Balakrishnan is not in a conflict of interest situation. And that Minister Shanmugam was in a position of potential conflict of interest, and that he took steps to make sure that he removed himself from that potential conflict of interest so that no actual conflict of interest could arise or did arise. And the perceived conflict of interest, I mean, as I explained earlier, if one has dealt with that there's no actual conflict of interest, there's no potential conflict of interest, then that should be sufficient to dispel the idea of a perceived concept of interest in any fair-minded person. So that's my view. The fact that, yes, he has some power over the appointment of the whether he assesses that the CEO of SLA performs well or not, that will always be there. All right? that can't, you can't remove that. But that will mean that the Prime Minister, for example, cannot do anything because he has powers over practically every agency in Singapore, right? So I think one has to look at the realities of the situation and what steps people have taken. And most importantly, to have confidence in the integrity of the public service and our public officers. And I think in this case, our public officers showed a very high degree of integrity. For example, when the management agent asked SLA, is there some VVIP track? The SLA officer replied emphatically to the management agent, no, there is no such thing. Every potential tenant or tenant has to be treated equally. And this is a testament to the quality of the public officers that we have. They know what integrity means, and they stand by it. And so I think we have to give credit to our public officers that they know how to behave and they know what to do. So that is a very important aspect of integrity of the public service. On the code of conduct, I would first like to dispel another misconception which Mr. Leong's question perhaps inadvertently perpetuates, that these relatively cheap bungalows. It's not true, Mr. Leong. It's not true. And you can see the facts for yourself that it is not true. And I hope that you will help to spread the word that it is not true. The bungalows are rented out at market rates. They're valued, 83% of them are managed by managing agents, about 17% are managed by SLA, and they are all rented out at market rates. The valuations are done by the valuation department in SLA, quite distinct and separate from the leasing department, as we've explained and has been demonstrated. They are also valued by the MAs. And the agents out there have a pretty good idea what they're worth. So I think we should dispel this idea completely, which I think Mr. Leong must have inadvertently sort of contributed to through his question, that these bungalows are going at a relatively cheap rate. I think also that Mr. Edwin Tong has explained why the expenditure is required to set these properties to make them habitable and rentable. I'm not a property person myself, but I do some simple arithmetic. If you have a property which is not tenanted and not in good condition and can't be rented out, you get no rent from it. But you have to put money in to cut the grass, to make sure the building at least remains in some decent condition, it doesn't sort of fall down and so on. So it's a complete loss to SLA if it doesn't put the property in a condition which is rentable. So when the prospect of a tenant comes up and the tenant is prepared to offer or looks like he's a credible tenant and looks like he can offer you a decent rent, then SLA says, I will put in the money if the resident is prepared, the tenant, potential tenant, is also prepared to put in money. And then we can talk. And the sums look large, $500,000 in round numbers, to put, SLA, as SLA says, to put the building back into basic habitable condition. But many of the things that they do will last for quite a long time. For example, if the water tank is in very poor condition, you replace the water tank, it will last you 10 years at least. If you have a problem with the roof and the roof is leaking, it will last you, when you replace it, or do major repairs on it, it will last you at least 10 years. If you have problems with the beams and the structures because there's a lot of wood in there, and you do work on it, it will last you maybe 10 years. So this is amortized over a period of time, and the SLA does its cost-benefit analysis to see whether it is worthwhile. So if a tenant is prepared to pay, let's say round numbers, $20,000 in rent, $25,000 in rent, $20,000 in rent in the first year will bring back $240,000, $25,000 will bring back $300,000. So within the first 2 years, the first 3 years, SLA will collect back somewhere between $600,000 and $750,000, depending, say, I'm getting my numbers mixed up also, say 500,000, 600,000, 700,000 from the rental in the first 3 years of rental, 2 to 3 years of rental. And after that, what they have done is still good for another 6, 7 years. So if you have a tenant who is prepared to rent it from you for 3 plus 3 or 3 plus 2 plus 2, and reliable and prepared to give you good rental, it is a worthwhile thing to do. Because otherwise, SLA will have to put in money every year to maintain the land, to cut the grass, to make sure that no mosquitoes, to make sure that this conserved property doesn't fall down and collapse. And it's a dead loss. Whereas by putting in that investment, they can get a return on investment over a number of years, which will then bring benefits to the state. And these are the kinds of trade-offs, cost-benefit analyses that SLA does, which I think the SLA officers do know and are cognizant that they need to do things which have value for money, good cost-benefit analysis, and bring benefit to the state. I think our public officers do have integrity, and they do look after the interests of the state and all of us.
Mr. Pritam Singh.
Deputy Speaker, clarification, please.
No, I've called Mr. Pritam Singh. Please. Thank you, Mr. Leong.
Mr. Deputy Speaker, I think Mr. Minister Shanmugam is not in chamber. My question is also directed at him. Perhaps we can move on and I can come back when Mr. Shanmugam
Very
is
well.
back in chamber.
I think Mr. Seah Yao Chen's question was not answered, and it was requested that it be answered later. Mr. Seah, would you like to repeat your earlier questions for Mr. Edwin Tong's benefit?
Thank you, Deputy Speaker. Sir, my question, actually that was my second point of clarification, but it was on land management. And specifically I asked about how much land, and what's the total land area that the state-owned portfolio of black and white bungalows sit on, and how might this factor into the government's weighing of both economic and social factors to determine how best to make use of this total land area and to manage a portfolio of black and white bungalows. Thank you.
So I had spent a large part of my speech outlining precisely that. We have a variety of different properties, heritage properties, the older ones. Black and whites is one category of them. And I've also outlined that as we manage them, as they get older in the portfolio, where possible, we try to look at other users. I've cited a number of examples to members in this House. And I'd like to assure Mr. Seah that moving forward, we will continue to do so. The buildings themselves, the properties, are the heritage buildings. If they're conserved, it is the building. Sometimes it makes sense to look at it in the context of the surrounding area, the land in which it sits on, or the adjacent property. And you don't want to remove it from the adjacent property and use it for other purposes that don't cohere with the status and symbol of the heritage property. So in terms of the land that is used, as I've cited my examples, I think some of them we have broadened it. We have mixed it up with other developments so that it is sufficiently vibrant. Its place, you make up the place and have a certain theme to it, like we do at One North and Rochester Commons, which I've cited. Other times, you want to ensure that the setting is preserved. It's not just the building itself or the property, but the setting in which it occurs, in which case you need more land. But yet other occasions, I've cited in Seletar, where you would take the view that there is minimal heritage value, probably more to be gained by combining it en bloc, redeveloping it, as we did in Seletar, and then it becomes an industrial estate. So these are the different uses that we have done in the past. We will continue to evolve this, and I would assure Mr. Seah that SLA is very innovative in not just how it plans moving forward, but also with the partnerships that it forms with private sector to ensure that we optimize the users, not just from a pure revenue generation perspective, but also making sure that we look at lifestyle, social users, and in some cases also social causes as well. Thank you.
Yes, Mr. Pratam Singh, the question that you wanted to ask previously.
Mr. Deputy Speaker, thank you. I think a number of members have come forward and asked questions since the first questions I asked. I'd like to put into context this command paper before the House. I beg your pardon, miscellaneous paper before the House. The fact of the matter here is I don't believe anybody is making an allegation that the minister is corrupt, somebody is corrupt in the system. I don't think, Singaporeans are not making that point. I think it's quite clear to me. The issue I think we're having to deal with here is the Ministerial Code of Conduct and a specific course of action that was taken by the minister when he instructed his DS to get some information. I'll just share the problem with that just over the course of the last 2 hours. Senior Minister Teo says it's not a secret list. Anybody can ask for the list. Minister Shanmugam is a bit more qualified. He says credible people will get the information. So within that, we can see some differentiation of why that information, to seek that information, could be conceived as, by some people at least, including myself, as actually seeking information which probably, out of a matter of prudence, would be better sought by an agent appointed by the minister, which was the question Senior Minister didn't answer in my first round of questions. Would it have been better, in his perspective, as the minister reviewing this episode, for Minister Shanmugam to appoint an agent, and he would still have been able to make the necessary declarations vis-à-vis conflict with his senior civil servants and so forth, which it would appear from SLA policy that the fact that the valuer didn't know who was the person ultimately who was going to rent the property suggests that this would not have been so much of a problem. So I think we haven't interrogated that and how the system can be improved if a situation like this comes up again. In my view, I think it is much more prudent in view of the Ministerial Code of Conduct, which is onerous, to keep the matter separate, keep the official matter separate, keep your professional matter separate. There's no need to ask a senior civil servant this information when you know you can get an agent to secure the same information. I'm not sure whether the senior minister can agree with that. The second point I'd like to raise is I think Minister Shanmugam spoke of an innuendo that when we ask questions about rental and land area being increased, that somehow this is a personal attack against him. Let's be clear, nobody is playing the man here. We're looking at the issue. And in this, and my point when I raised my first set of questions was, there's a question of political optics. When we want to rent, let's say, a landed property, an intermediate terrace house would cost less than a corner terrace or a semi-detached house. Why? Because the land has utility. If you are a pet lover, you can clearly see that connection. If you have a big family like Minister Vivian, that land, the additional land, has utility. Hence, in the minds of people, the view is surely there ought to be some value attached to that, notwithstanding the clarification Second Minister of Law made about how the valuers in SLA look at it. I think that's the public perception that has raised some of these questions that have come to bear. I just have a final point which was really triggered by what Member Zulkarnain asked. He asked about the statement and the process of the CPIB investigation. Can I just confirm with both ministers, in the course of the investigations, were your mobile devices seized by CPIB and returned at the end of investigations? Thank you.
Mr. Speaker, sir, Mr. Deputy Speaker, since we are coming towards the end of the first theme, which is whether there's wrongdoing, conflict of interest, and whether there were private benefits derived by the ministers through abuse of power, I'm very happy to hear Mr. Pritam Singh say that nobody is alleging corruption. And so my take is that this House actually concurs that there's no wrongdoing, there's no corruption, there's no abuse of power. That's my take, because that is the same conclusion that I come to, and we are at one, Mr. Pritam Singh. So the issue now is one of perception of conduct, of conflict of interest, right? So we agree there's no corruption, abuse of power, and so on, and personal benefit gain. The issue now is one of conflict of interest, actual conflict of interest, potential conflict of interest, perceived conflict of interest. And we have gone through this a number of times. And before I go any further, again, I said anybody can get the list. And this is in the context of anybody who is a credible potential tenant, right? And that is clearly the context in which I made that comment. So there is no air gap between what Mr. Shan said, Mr. Shanmugam said with regard to credible tenants and what I said. So there's no difference in that. So on perceptions, conflict of interest, I can only repeat what I said earlier. There is potential conflict of interest, there is actual conflict of interest. Two elements must come together for these to exist. There must be a duty and coming from the position which the person holds, which impacts upon the second factor, which is a private interest of that person. If those two come together, then there's a potential conflict of interest. If that person does something or exercises the powers that he has in a decision which affects his personal interest, then that's an actual conflict of interest. But once either one of these two is removed, then there's no actual conflict of interest or potential conflict of interest. And as I said, I think that if one explains it and looks at it properly, any fair-minded person will then say, if there's no potential conflict of interest or actual conflict of interest because the potential for that has been removed, a fair-minded person will then say, then the perception of a perceived conflict of interest should be dispelled. I think that's what a fair-minded person will come to. So those are the points that I want to make. And I think I will stop there and let Mr. Edwin Tong respond.
Minister Shanmugam.
Mr. Deputy Speaker, sir, just a short point before Minister Tong responds on questions and innuendos. I want to make it very clear, as I said in my personal statement earlier, ministerial statement, I welcome questions. I think it's important that we discuss this robustly, thoroughly, fully. That is how we keep the integrity in the system. And I don't run away from any of the questions. In fact, I wanted a full, in-depth investigation. And there was a full, in-depth investigation. The point about innuendos, I mean, we can go through the different questions. The point is, main point for this House is our conduct, the reports, what we did, what we didn't do. Was there anything wrong? Did we benefit in any way? These are relevant questions because this government and Singapore the bedrock is integrity, financial integrity. And if we are not prepared to come up and have ourselves being questioned, answer, explain, let Singaporeans judge for themselves. What did we do? The leader has talked about optics. I think if necessary, we will talk about the optics too. But first, we want questions. We want to answer all the questions. And I fear no questions.
Minister Edwin Tong.
Thank you, sir. I want to go back to the point that Mr. Singh, LO, raised about the valuation, and I think you said SLA's valuers. I was quite careful to say that it's not just SLA's valuers. This is a view that's taken of the market, and we have to be guided by market forces in how we look at this. When we say it is the GFA that is the main factor that determines the price and the marketability, it's not just an SLA position or a policy position. Is that taken by the industry, by the market? And I pointed you to the annex in in SMTO's report, because that represents all the black and whites in Singapore. And the majority of these black and whites, to be precise, 87% of them are managed by professional MAs, managing agents. And each time they do a transaction, they use their own in-house independent valuers to make that assessment as to what the guide rent ought to be. And they are not told by SLA what the guide rent should be or how to determine it, but they go back to market forces. So this is a factor that is looked at, and it has to be looked at in the context of what's the right market, what are the right market forces to it. And I mentioned too in my speech that each of these managing agents, their arrangement with SLA incentivizes them to maximize occupancy and drive rental. That's their KPI. So there is no incentive for them to try to assess a guide rent otherwise than by market forces. And so I hope that puts this matter to rest, because it's not that GFA is the only factor. Neither did I say that. Land is, of course, relevant. Location, condition, and all these are factors that I think I mentioned. They're all relevant. But the main factor when it comes to a black and white heritage property is really the GFA. Thank you.
We've concluded the first theme, which is, as I understand it,
I think, Sir, Deputy Speaker, sir, I think Mr. Singh asked if they looked at our emails or phones, whether they seized the phones. My phones did not have any relevant messages because they automatically delete, and CPIB looked through it. There was no need to seize them because, that's a setting on my phone. They looked at and asked for and looked at my emails.
Mr. Deputy Speaker, I have had absolutely no communication with the property agent or with SLA, so there was no need for my phone to be surrendered. However, I should add that every single message between my wife and the property agent and the managing agent, and subsequently with SLA staff, was in the hands of CPIB. Because you might remember when you send a message, it's two ways. So they had sight of every single message. It just shows you the thoroughness in which this investigation was conducted. I assume the vast majority of you here have never had the privilege of interrogation by CPIB. Let me assure all of you it is a most uncomfortable, invasive, intrusive, thorough process, and I don't wish it upon any of you.
In what Mr. Williams said jogged my memory. While there were no messages on my phone, all the messages that I exchanged they had, and in fact, I was asked questions on some of them, because some people keep messages for 5 years, and those messages were taken by CPIB from others who had sent me messages. I recall, I don't know what they have, I don't know what they don't have, but I was shown some. So I assume that, messages that were sent to me, or messages that I sent, which were still available, were seen by them.
You have a final point on this theme, Mr. Singh?
Yeah, so just to confirm, it would be correct for the record to say the phones were not seized.
I think correct to confirm is that phones were looked through, and since there was no relevant material, they were given back to us in the course of the interview.
My phone was not seized.
That concludes the first theme.